There's really nothing to be added.
Nothing to repeat. Only then I would just have pointed out the relevant pages of my written submission. That's all.
So that we'll read it, don't worry. We'll read it in.
Thank you. Yes, we'll read the submissions. Yes, Mr. Dewan.
I appear for respondents 1, 2, and 4. I appear with Mr. Nikhil Nair. We will divide our submissions. For respondents 1, 2, and 4. I'll request the court master. Yes,
Dewan, one thing, since we have now renamed the title of this proceeding,
yeah,
the object was also to assuage your concern on behalf of your client that we shouldn't look into the curative aspect, or that you have a preliminary objection to the curative issue.
Yes.
We'll be sending it back to the
yes,
five-judge bench
so
on the
that
curative.
after hearing us on curative, your lordship may consider whether that's the correct course at all. Because in my respectful submission, that may not be the correct course.
We really want your assistance on the question of law.
I'll do that as much as I can, but we'll do that in 2 stages.
Your client on facts and whether curative should be exercised, we'll leave it to the 5-judge bench, and we are not going to come in the way of your client saying that, look, please dismiss this curative because they have no case on merit.
I think, okay, so let me, I've understood what your lordship is indicating. Now let me contest that position and suggest that there is a better way forward.
Yes.
So let me first, so I am going to be making my submission very rapidly because of the constraint of time. I will state my points. I'll request the court master, if you consider it convenient, to hand over. I've given a list of the Constitution of India, the Stamp Act, the Arbitration Act physically, because it may take less time that way. That they may.
We have it with us.
Now let me just, so I have 2 broad sets of submissions. I am first setting out my points with regard to my first set of submissions. The first submission is that our court, which is the Supreme Court of India, as we understand it, is a means and ends institution. We are very particular about means and ends when it comes to courts below, when it comes to government authorities, when it comes to citizens, and most important, when it comes to ourselves. Because the reputation and credibility of our institution rests on the foundation that we reject expediency. We do not. We have sometimes very honorable objectives, but we do that as the apex court in our country, following, reaching those ends by permissible means. And that is going to be my first point with regard to means and ends, the importance of means and ends, and the importance of the nature of jurisdiction which your lordships is exercising. That's my first point. I now come to my second point. Let me indicate what we are not exercising first. So first and foremost, as your lordship correctly put to me, that look, we have relabeled this, and I'm very grateful for that, because I think it really helps, because the parties know, individuals who read the judgment know. So I think it's very beneficial to have an appropriate caption for the case rather than this. But the caption and altering the caption, does it alter the nature of the jurisdiction which you are exercising? So I ask myself a simple question. What are the jurisdictions which this court indeed does exercise? Are we in the realm of appellate jurisdictions? The answer is no. It's not appellate constitutional. It is not appellate statutory. Is it review jurisdiction? The answer is again no, because review, as I will indicate to your lordships, has been rejected. Are we in a jurisdiction which is original, like 131 or 32? The answer is no. Are we in a jurisdiction of discretionary appeal? The answer is no. Are we in a jurisdiction on an opinion which the President of India seeks by way of a reference? The answer is no. Are we in a transfer jurisdiction? The answer is no. So then what is our jurisdiction? What is this panel constituted exercising? There must be jurisdiction. This is the primary function of every court. You must be satisfied. I'm only saying that. You ought to be, I can't say must be. You ought to be satisfied that the jurisdiction which you are exercising in a panel of seven, I'm sorry.
Where a 5 judges constitution bench has found the view taken by earlier 5 judges bench.
Yes, yes.
To be prima facie not correct.
Correct.
Is a reference to 7 judges not called for?
Yes. So let me answer that straight away. If in an appropriate jurisdiction, I answer that straight away. If in an appropriate jurisdiction, your lordship's exercising a jurisdiction, your lordship finds that a 5-judge bench is not appropriate prima facie or otherwise, by all means, you have the power to do so. So I concede and I accept that, but not in the curative jurisdiction. Now I'll come, so let me answer that question straight away first.
Sivan, the only problem is.
Yes,
Exactly.
I'm so
That
sorry.
doesn't-
Sorry.
that doesn't-
No, there are fundamental issues. I'm sorry.
That doesn't really survive, subject to what you say.
Yes, yes, of course.
Because even when you were arguing earlier,
Yeah,
you said this is not a case for curative.
sorry.
This is not a case for curative.
That's my submission. I mean, it's ultimately for the court to hold.
Case for curative, you may be right, you may not be. We can't say
Correct,
that.
correct, correct.
But you said, look, don't in a curative petition appreciate these submissions.
I'm sorry.
Don't appreciate these submissions or debate these submissions in a curative petition. Correct?
Yes,
That was your submission.
that's what means and ends is about. You must be exercising a legitimate jurisdiction. Legitimate meaning is not that it's illegitimate to exercise. It is curative. The point I'm making is your lordships are sitting, exercising a 7-judge bench, and I have no problem with 7-judge bench at all, or 9-judge or whatever. But the issue still is the core nature of your jurisdiction today is curative and nothing else.
So Sivan,
Which
what
takes
happens
us
is
to, I'm sorry.
When a position of law,
Fundamentally,
when a
yes.
position of law,
Yes,
we are a constitutional court.
yes, of
When
course.
a position of law is liable to cause grave public injury,
Yes,
public uncertainty,
correct.
and grave unsettling in
Yes.
the world of business and investment.
Yes, yes.
Surely, the point of time at which the controversy should be resolved should not be left to the vagaries of future litigation. It's the duty of the court to seize upon
Eh,
the
well,
opportunity
yes.
and
Answer
at
is
the-
yes.
And at the end of it all,
Yeah.
at the end of it all, we may still dismiss the curative petition against
Yeah.
you.
So the answer is yes.
Because we
I-
are equally conscious of the need to do justice to the facts of that case. So the curative petition can be
That-
still dismissed after the decision of this court is rendered,
So let me answer. So,
setting the law correct.
Manoj, let me just answer that. First and foremost, if this court finds in an appropriate jurisdiction and in an appropriate cause that there is some decision which requires reconsideration, which is absolutely your function, and I would take it higher, even perhaps your duty to correct the position in law, it ought to be, as we understand it, in an appropriate proceeding. So now let me just answer the questions which your lordships have put to me. There are two ladders here. The first ladder is a curative ladder. As we understand it, the ladder narrows in the sense, in our understanding, review jurisdiction is narrower than the main appeal, and curative, in our understanding, is narrower still than review jurisdiction. If that be so, then this is a very narrow issue. So I come to my second point. Curative, as we understand it, as understood by this court, and I'll place those decisions, is with regard to doing justice for a particular individual cause. When we go to Hurrah, your lordships will see, it's a case in that case to do complete justice, that individual case. The curative jurisdiction, there may be several situations where you have incorrect law or something which is staring in the face. We don't accept that we'll come to, of course. But it's very important to follow the means and ends test. And I'll tell your lordships why. NN Global ought to, it may come up on an appropriate separate ladder. Curative is a 3-rung ladder, as we understand it. The first rung is the disposal of the case itself. The second rung is there must be a disposal as far as the review is concerned. And the third rung is thereafter a curative petition with all the safeguards that the court has laid down. That's the 3-rung process of reaching this court in curative jurisdiction. Now is a submission. You cannot bypass these 3 rungs because, and let us remember, the curative jurisdiction, although now in our Supreme Court rules, your lordships have continuously exercised, it's a self-created jurisdiction. It's a jurisdiction because the demands of justice sometimes stare an apex institution like your lordships in the face. And oh my, how have we allowed this to pass? And in a situation such as that, for that individual case, yes, you have created this very, very narrow jurisdiction to yourselves, required an appropriate certification, restricted it to grounds, and said that and only in those cases, even though you don't find any provision in a statute or the constitution, we will, because it's our paramount duty, and you trace it to 142 as we understand. So 142 generally may be wider. 142 as a source of power for creating curative and for exercising curative as we understand it is limited to a cause, to a particular individual cause. That cause may, in certain situations, affect a large number of people. I accept that. But here, what has happened is, now, Manoj, I'm just answering the question. Sorry.
There can be a legal cause and there can be a factual cause.
So, yes, let me answer that. Yes,
Factual cause is being segregated, as the Chief Justice put to you,
yes,
to keep the curative aspect, in a sense, out of it.
yes,
But we do believe,
Yeah.
several of us do believe,
yes,
that there is an unsettled legal position
yes,
about the facts,
yes.
which has own ramification, and the Chief Justice put it, it becomes the court's duty to, in its endeavor.
So I quickly end that. I quickly answer that. My answer is yes, it is the duty of the court. But if we are right on means and ends, then it's a duty of the court when and where. So I'll come to that straight away. It is the duty of the court when NN Global in an appropriate proceeding is doubted, the 5-judge bench. It goes by way of review and then it is before curative. That is a separate ladder. And it's important to maintain these ladders. It is not permissible, according to us. I mean, it's not permissible, it is not desirable, and according to our understanding of the law as laid down in the judgment so far, it is, your lordships have restricted curative continuous. I mean, restricted in the sense when the justice of the case demands, so I'm sorry.
Difference of perception on this issue.
Yeah,
The issue is that someday your submissions
Yeah.
are bound to be affected or colored by the fact.
no, but
that
your lordship,
why in my curative petition?
sorry.
Why in my curative petition? Why are you doing this in my curative petition? That's the bottom line of what you're saying.
No, that's not. There are two elements here. The first element, your lordship is right, that it is in my, because I'm briefed in this case, so I have to say that please, I mean, don't upset my apple cart.
Correct.
My agreement, by the way, I mean, this is quite amusing. My arbitration agreement is of, your lordship will not dare suggest the year. It's of 1997. My arbitration agreement is of 1997, and I was telling
Why
you,
your curative has been,
26 years down the line, we are thinking of appointing an arbitrator. And I mean, what a joke.
On the
But for the fact that it's a serious question of law, which your lordships are considering. Sorry.
I told my Chief Justice on the lighter side in Chennai, I have had to refer an arbitration in the year 2015, an application filed in 1999. It was a live dispute.
Yeah.
It was accepted as a live dispute and I had to refer. The unfortunate part was that the only unfortunate part was the application was not taken up. So therefore, we are not getting into the facts of it. Therefore, I feel you are more troubled by the fact that why are your clients being troubled in a curative jurisdiction?
So I
We
will.
are therefore at the threshold itself, looking to your submissions on the earlier day.
Yes, yes,
The five
yes.
referred to the same.
Yes,
We thought we had taken care of this issue
yes,
by not looking into the curative issue at all.
yes.
And that's something, Mr. Datta. So the curative will be.
But the question I asked, then I mean, of course, a Chief Justice can constitute a panel of 7. But then what's the jurisdiction that this court is exercising
It is
today?
determining the legality of the view taken by a
That's
that's
an opinion or a reference which the President of India has sought. Which is this jurisdiction? It is only curative. Anyway, let me just, sorry.
Mr. Diwan, your
Yeah.
basic objection seems to be
Yeah,
that while examining a curative petition,
yeah.
the legal ratio raised in the decided in judgment should not be relooked at by a larger bench.
I'm sorry, Manoj. Read last.
While examining a curative petition or while
Yeah.
deciding a curative petition,
Right.
the legal ratio raised down by a 5 judges bench or any smaller bench should not be looked into.
Yeah.
That's a larger perspective, but in a given case,
Yes, yes.
where we find
Yeah.
that the business ramification or other issues have arisen, which have raised some
Right.
doubts and issues.
Okay.
Why not examine it? We are not saying that curative petition is going to be examined on facts itself separately. So if there is some doubt or debate on the legal principles laid down, legal ratios laid down, which
Right.
have wide ramifications in fact, why can't we
Right.
go into that?
No,
Why should
sorry.
we?
Yeah, I'll tell you, Lord.
Then the mean is really speaking. Here, the means are right because if there is some issue which has arisen, which has led to
Yeah.
a lot of disturbance, then it's the right means to also check it.
Right.
It's not something that we are usurping a jurisdiction which doesn't rest with us. We are all adjudicators. We have to adjudicate. We keep on re-examining ourselves, correcting ourselves. That's our jurisdiction.
All right, so now I've followed. So let me just be very brief on this point and let me give you the page numbers and the dates. may I just indicate, I'm not, Manoj, please don't misunderstand me. I'm not saying that a 7-judge bench can't overrule a 5-judge bench. That's not my case. My submission is, of course you can. But if we are a means and ends institution, then it ought to be in an appropriate packaged case and proceeding. And this may not be an appropriate proceeding for 2 reasons. Now, let me just, for several reasons, let me just indicate those. And since your lordship, I'll state the points. If your lordship wants me to go to it, I will go to it. But I mean, we have the pages here. So the first point is that the ground given, please just note this. The first point is that the ground given insofar as the curative petition as contained in the certificate is that there is a reference which has been made to a larger bench in NN Global. So this is the primary ground. This, in my respectful submission, cannot be a ground for the purposes of issuing a certificate. Your lordships have deprecated certificates of this type, and I believe it ought to be deprecated here merely because there's a reference which has been made to a 3-judge bench. So that's absolutely no ground. Now, if there is no ground which is made, which is sustainable insofar as a curative petition is concerned, the question of igniting the curative jurisdiction does not arise. So this is one primary set of submissions that I have. If your lordship likes, I can give you sorry.
Security with it. That's the. When 5 judges may be sitting in curative jurisdiction. He is not denuded of the power to constitute a larger bench to examine the question.
I agree that. I agree with you.
That's all we are doing.
So, Manoj, may I just say this?
Even there, we did not let them argue even further. Is something which needs to be looked into or relegated to arbitrators. There also we have not permitted them to expand the contour. We have some of them.
So,
have argued
anyway, your lordships have followed my point now. So I'll just give you the points. So the first point is
we are
that,
giving you
sorry.
we are leaving it to you to fight another day on the curative petition. We are not dealing with that aspect. We are today not these taken.
Well, I think, frankly, I mean, I'm just making a suggestion. If you do find in my favor that the essential elements for a curative jurisdiction are not made out, then my respectful submission would be the appropriate course is to decline to exercise this jurisdiction, because you are exercising no jurisdiction other than curative today. When you pass the order suggesting that you are clarifying it, etc. There is, sorry, that's my understanding of the law. But I mean, if your lordship finds that there is some other jurisdiction which is also being exercised over here, I don't find any. Sorry.
We've said repeatedly that so far as the curative matter is concerned, it will be heard by a 5-judge bench. Whether they agree, disagree, dismiss the petition, the facts of the case is a separate matter. But on a general principle of law, 7 judges of this court felt, led by the Chief Justice, who exercised his discretion. We have segregated it yesterday. We have said we are only.
So let me just proceed now. I've followed the point. So let me just state my points, and then your lordship will consider them appropriately. So my first submission is that by relabeling it as in re, etc., it doesn't alter the nature of the jurisdiction or exercising. That's my understanding of the law. The nature of the jurisdiction remains the same. That's point 1. Point number 2, if you are choosing to exercise curative jurisdiction, which of course you may, there are well-settled parameters, and I'm just indicating those parameters. I'm just mentioning them because they're in our submission. I'll list them. Sorry.
Mr. Davin, the problem is, Mr. Diwan, that we are not looking into it. So you're arguing something which we are not looking.
No, but if it's curative and then your lordship say that it is,
it's a catch-22 situation.
It is a catch-22.
You can't do it in a curative because there are restricted parameters. Okay.
All right, let's keep that aside. Let's keep that argument.
We are not doing it. We are only looking to one proposition of law. He holds the curative.
All right.
Whether in case of a 11-6 jurisdiction,
all right,
stamping is something to look about.
Okay, so now let's drop this. Now, I'll next 3 sentences I'll try and not use the word curative. Supposing in a theoretical situation, a very, very wrong judgment comes out by this court. And it is brought to the attention of the Chief Justice of India or senior judges, etc. That look, this looks, extremely wrong and very perilous. The question I ask myself is that can the court thereafter constitute a bench of a larger panel, put a label in re, and then decide the issue to overrule that? I don't believe that is acceptable. That's my understanding of the law. I believe that can certainly be done in an appropriate case. An appropriate case comes up. That's what means and ends is about. But not, sorry, that's our understanding.
The impact of a wrong precedent is
Yeah.
so severe.
Yeah.
And as our history has shown, by the
Yeah.
time you actually get a case, an appropriate case, what you have to ensure is that you do not confine your arguments only to one or two.
Yeah.
Therefore, we have invited a broad diversity of views.
Correct.
On this side,
Yes.
on this side, we have, that's the
So
idea.
let me, Manoj, move on. So Manoj, I said I won't use that expression. My understanding of the law is merely because there is a wrong judgment. Our understanding of this institution and its working, our understanding of this institution and working is that we improve, we self-correct, but there are methods and ways of doing it. And I am suggesting to your lordships that this may not be the appropriate way of doing it. Your lordship's answer is we are keeping your objection alive for another day. Fair enough. But then what's the nature of the jurisdiction in arriving at this conclusion of whether X is right or whether wrong? It is the jurisdiction which I said I won't speak about. So that's the very jurisdiction. Now, if that's the jurisdiction, then please follow the parameters. Now I move on. You may just note that in my case, there is a 337 days delay in file. So I've said the certificate isn't there in terms of Rupa Hurra. I have respectfully submitted that the agreement itself, of which the arbitration clause of 1997, so please keep that in mind. There is a 337 days delay, and there is a 505 days delay after the dismissal of the review, a 505 day. And your lordships have said that as far as a curative petition is concerned, it cannot be filed as and when a party considers it. So, sorry. So this really ought to be closed. I'm sorry.
I'm only saying you will argue this somewhere else. That's all I'm again. So we understood your point. You say, why take it up here?
That's really up to the court to hold as to whether there is a means and ends.
understood
There
the
is
first
something in
point.
the means and ends submission.
We have understood your means and this thing.
Yeah.
Point.
Yeah.
You feel no, there is a procedure which must be followed. We felt that it is a very large ramification. We should not wait for a particular case to arise, then to be referred to 3 judges, then to be referred to 5 judges. That is why Chief Justice placed it. We have heard not the parties alone, we have heard everybody. So this is not something which is a list being decided and to see the parties in that sense. And therefore, at the threshold, we kept it. So to the extent you feel don't do it in this manner, we have understood it.
Yes.
Whether we
Ought
agree or
not. Well, I said I'm not saying don't do it. I'm saying we ought not to do it.
Not to
I
do
mean,
it,
who
but
am I to say don't do
on
it?
the lighter side, we've
No,
done
no.
it.
Means the same
We've
thing.
done it.
Perhaps ought not to do it. That's how I'll put it.
We've done it now
Yeah.
because in this manner, we feel we
Very
have to
Very
close.
well. Anyway, your lordships have now followed the point. So I now move on to my next point. Now, your lordships have the Arbitration Act with you, or should we go to the sections which are mentioned here? Okay, let me just indicate to your lordship. I'll take you to the act as it appears from the record. I've now kept that whole issue aside. Now, my lord, sorry.
I understand you correctly that
Yeah.
as a proposition of law,
Yeah.
we want to canvass that the issue of a stamping of an agreement
Yeah.
should be looked at in 11.6 itself.
Yeah.
Is that the proposition you are advancing?
Yes.
So it has-
Yes. So, Manoj, let me
you
just
are-
let me simplify.
You are in different jurisdiction.
Okay, so let me now, Manoj, I have to let me simplify. Let me give you my understanding of the law. If we take up the Arbitration Act or whatever electronic copy your lordships are referring to, there are 3 situations which arise. So I'll give you my conclusion on all 3. The first situation which arises is the law as it stands today. If we pick up the Arbitration Act, I'm only on 11.4 at the moment. You could have a Supreme Court / High Court appointment, depending on international or domestic. That is situation 1. Situation 2, as 11.4 stands today, it could be through an institution which is designated or appointed by for the purposes. That's the second situation. So 11.4 as it is applicable post 2015 Act today. The third aspect, the third dimension is what Mr. Khambata mentioned briefly, which is that, look, we now have a 2019 statute which has not been brought into force, which sends the matter, Justice Khanna also mentioned it, which sends the matter into the realm of an institution, correct? So first, let me clear my position. If it is to go, 11.4 is to go directly to an institution, in my understanding of the law, there is no impediment in terms of stamp duty. So the moment the 29, and that's in fact one of the reasons why I'm going to request the court, please do not exercise such jurisdiction as you are choosing to exercise. Because there is already a statute. The statute refers parties straight off to the 2019, under the 2019 amendment, to an institution. It does not require any interference or any intervention by a court or any application of mind on the part of the court. That body will not be a body which is entitled either by the consent of the parties or under law to receive evidence, and therefore the stamp duty question will completely pale into insignificance. So that's one situation. So it will not apply. So this problem won't arise. All that is needed is the 2019 Act is brought into force, the relevant provisions, and the problem disappears. That's one. So this has, of course, multiple dimensions to it, including whether your lordship should even at all exercise jurisdiction. You'll keep that at the back of your mind. Now we come to the second situation. The second situation is, your lordship may just go to section 11 for a moment. Just have a look at section 11. As it stands today, you will find it at page 1210 of volume 4A. Your lordships have it? Yeah. So, fellows, I'm now reading 11, appointment of arbitrators. We are on page 1210. Appointment of arbitrators. A person of any nationality may be an arbitrator unless otherwise agreed to by the parties. Now, subsection 4. If the appointment procedure in subsection 3 applies and a party fails to appoint an arbitrator within 30 days from receipt of the request to do so from the other party, or the two appointed arbitrators fail to agree on a third arbitrator within 30 days from the date of appointment, the appointment shall be made upon request of a party by the Supreme Court, or as the case may be, the High Court, or any person or institution designated by such court. So again, I'm just indicating to the court our position. If under the law, now 2019 Act, I've said, that is not brought into force. Even under the law as it stands today, there are two situations. One, which is the one which commonly prevails, which is that the High Courts and the Supreme Court continue to appoint. But there is also an expression, or any person or institution designated by such court. Now, when this went before the High Power Committee, or what Mr. Khambata referred to as the Sri Krishna Committee, they looked at the provision as amended by the 2015 Act, and they, following on the earlier law.